5 seconds to go. Start. The submission of the learned ASG is that the provisions of Section 45 of the PMLA would come in the way of consideration of the application of the appellant for grant of bail. From the first order of this court, it would be clear that an assurance was given at the bar on behalf of the prosecution that they shall conclude the trial by taking appropriate steps within next 6 to 8 months. In view of the said statement, this court did not consider the application of the appellant for bail at that stage, however, granted liberty to the appellant to move a fresh application for bail in case of change in circumstances or in case the trial is protracted and proceeded at a snail's pace in next 3 months. Though this court observed that if any application for bail was filed on the grounds mentioned in paragraph 29, the same would be considered by the trial court without being influenced by the dismissal of the earlier bail applications, including the present judgment. However, it clarified that the observations made by the court with regard to right to speedy trial would be taken into consideration. The liberty was also granted to the appellant to file an application for interim bail in case of ill health and medical emergency due to illness of his wife. A perusal of the impugned judgment and order would reveal that though the learned single judge of the High Court has dismissed the applications for bail on merits on medical grounds, it has permitted the appellant to visit his residence to meet his wife in custody once every week. It could thus clearly be seen that this court expected the trial to be concluded within a period of 6 to 8 months. The liberty was reserved to approach afresh if the trial did not conclude within the period of 6 to 8 months. The liberty was also granted in case the trial proceeded at a snail's pace in next 3 months. A perusal of the material placed on record would clearly reveal that far from the trial being concluded within a period of 6 to 8 months, it is even yet to commence. Though in the first order of this court, liberty was reserved to move afresh for bail if the trial proceeded at a snail's pace within a period of 3 months from the date of the said order, the commencement of the trial is yet to see the light of the day. In these circumstances, in view of the first order of this court, the appellant was entitled to renew his request. When the appellant renewed his request, the learned special judge trial court as well as the High Court was required to consider the said applications in the light of the observations made by this court in paragraphs 28 and 29 of the first order. In paragraph 29 of the first order, this court specifically observed that though the observations on the aspect of merit were not binding, the observations of right to speedy trial were required to be taken into consideration. The learned special judge and the learned single judge of the High Court have considered the applications on merits as well as on the grounds of delay and denial of right to speedy trial. We see no error in the judgments and orders of the learned special judge as well as the High Court in considering the merits of the matter. Stop.